On this episode of Law Weekly, we have the views of a recently retired Justice of the Supreme Court, Justice Ejembi Eko, on the interference of the executive in judicial appointments, the poor pay of judicial officers, and lots more. Also showing on the program highlights from the 6th ICC African Conference on International Arbitration, which just ended in Lagos, Nigeria, plus a recap of some of the top trending legal stories. Hello and welcome to the program. I'm Shola Shuyeli. He was born on the 23rd of May 1952 in Benue State, and he recently retired from the Supreme Court bench after clocking the mandatory retirement age of 70. I'm talking about Justice Ejembi Eko. After the valedictory court session held in his honor at the Supreme Court on the 23rd of May to mark his exit from the bench, the legal community held another event a few days later to celebrate him, a book launch which also held in Abuja. The book had the title, Honorable Justice Ejembi Eko Dissents. It's a collection and comments on his lordship's dissenting judgments at the Supreme Court of Nigeria, one which attracted family, friends, and many who admired the stance and dignity of the retired jurist.
We will see in this book why lawyers and jurists in Nigeria refer to my lord as one, a rebel with a good cause, a jurist with positive rebellious erudition, who is rebelliously positive or positively rebellious, all for the interest of justice.
The chairman of the event is the former Attorney General of the Federation, Senior Advocate of Nigeria, Bayo Ojo. He and many others spoke about the admirable qualities of the jurist.
It is indeed a pleasure for me to be here to preside over the book presentation in honor of a quintessential jurist and remarkable gentleman, Honorable Justice Ejembi Eko. Someone whose private and public life epitomizes outstanding character.
I described him as Londini because he was in love with dissent. He's always dissenting, always. I say, yeah, that's our Londini. But he also expresses the mathematical intellect of Londini in his judgments.
One of the most notable dissenting judgments of Justice Eko was in the case of Eyitayo Jegede and 10 others against INEC and 30 others, where the bone of contention was the legal implication of the executive governor of Yobe State, Mai Mala Buni's act of presiding over the nomination and sponsorship of Governor Rotimi Akeredolu in the Ondo State governorship elections of October 10, 2020. The majority decision was to the effect that even though the executive governor of Yobe State acted contrary to the constitution, since he was not joined as a party to the suit, the election could not be nullified. But Justice Eko, in his dissenting judgment, upheld the supremacy of the Constitution and was of the view that since the APC had been joined in the suit, it was needless to join the governor of Yobe State, since as a governor he was covered by immunity as provided in Section 308 of the Constitution. The book, Honorable Justice Ejembi Eko Dissents, is edited by two senior advocates of Nigeria, Ogu James Onoja and Fumi Quadri, with contributions and analyses by 27 other senior advocates. After a brief review, the book is unveiled and formally launched. The celebrant speaks about his judgments.
Justice Okoro wrote the lead in Karufi against APC. But before then, I had submitted my different opinion. After some delays, Okoro changed his mind. Not only just Okoro presiding, changing his mind, he also it became a unanimous decision. That was a decision followed by Honorable Justice Galumje that produced the Zamfara case. And yes, I've been told here that Section 294 allowed me to express my opinion. But I have the natural right of opinion, again guaranteed by Chapter 4, reinforced by Section 294 of the Constitution. So, for those of you who are sitting, for those of you who are practicing, when you hold a strong view, express it. You may not know, as a Idoma man says, you may not know the arrow that kills the elephant. So that's the risk I've been taking. So it appears I've killed some elephants.
After the book launch, I sat down with the retired jurist to get his views on some prevailing legal issues. I began by asking him to shed more light on the appointment of chief judges and the role of state governors. Justice Ejembi had said in his valedictory speech that he was a victim in 2006.
The Constitution vests in NJSC to make recommendations, interview, recommendations for appointment of chief judges of the various jurisdictions. Mind you, we have a unified judiciary, so to say. But when it comes to, during the military era, it was not politicized. But now, it has been politicized. What was thought to be a seamless transition. Mind you, the way we have adopted under our system, unlike America, where the chief executive nominates the head of court, even it may be the lowest, but once what determines it is his management skills. Here, the most senior, I won't say it's gerontocracy or primogenitorship, but that is what it looks like. So the most senior is usually recommended for appointment as and the Constitution says whenever there is a vacancy, the most senior will act for some time, pending when the substantive appointment is there. So invariably, NJSC acts on that seniority, and then when they make recommendations. And most chief executives, governors particularly, it doesn't happen at the federal judiciary. It happens at the state level. Governors say, no, I can't, this person I cannot, I want somebody I cannot work with. So in my own case, I won't call names. Ejembi is too strict. If you make him chief judge of Benue State, you should forget about winning elections. Am I your chief dog? Not this. And throughout my life, throughout my tenure as a judge, I never went to government house unless on official, formal location. Every other person is there. I have no business with the governor. I have no business. I live within my salary. So, because I held myself aloof, and I say, why should I deliver judgment against government? But there is equality before the law under the Constitution. So the government, as a litigant, is equal in law between me and the litigant. At a point they say, oh, I deliver so many judgments against government. Oh, if you make him a chief judge, you should forget about winning election. Because most of the governors tend to believe that the chief judge is part of the cabinet, and enlarge the cabinet, kitchen cabinet consultancy. Even me as Solicitor General, then I never accepted being too political. And so I was expected to be at the airport whenever the governor, what should I be doing there? I'm an outdoor worker, I stay in the court. So I never once went to the airport to receive the governor. So not to talk about the chief judge. So in most cases, the Constitution that empowered the NJSC to do that hasn't given enough enforcement powers to the NJSC also. So it's more or less a toothless bulldog.
So may not propose that we tinker with that part of the Constitution?
Yeah, we can, but have they done it? The Constitution, and mind you, Nigerian Constitution is very unique. It carries a tag of being federal, but are we really federal? It's a unitary system. Since Ironsi with Decree 1 tinkered with the federal system, and then came with the unitary, the coup that ousted Ironsi that brought in Gowon. The main reason they gave for ousting Ironsi and killing Ironsi was that abrogation of the federalism. But did they revert us back? They didn't. Their own unitary system is even worse than what Ironsi did. That was what was proposed to be at the Aburi Conference was supposed to be. So if we had adopted the Aburi Conference, but incidentally, the federal government headed by Gowon then rejected the Aburi Conference. And what we have now in the pretense of federalism is actually federalism, it's a completely unitary system.
Let's talk about money, and especially the issue of the need for a review of judges' salaries and compensation. Millard raised the pertinent issue and asked the NJC, the Federal Judicial Service Commission, and the Revenue Mobilization, Allocation and Fiscal Commission to synergize and introspect and tell the world why since 2007 there has been a dereliction of duty on their part to review the salaries of judges. While we hope that they take up this challenge, can Millard tell us in practical terms what has been the implication of this on the judges?
It means that the inflation trends, since they are not at pace with the inflation trends since 2000, and they have been reviewing other sectors.
Since
2007. And Section 84 of the Constitution, completely, they are the people to propose the review. So why I say NJC, because NJC by paragraph 21E of the third or fourth schedule to the Constitution is the one saddled with payment of salaries of the recent. Why won't NJC now say, oh, you haven't reviewed this judge? And we've been holding all judges' conference resolutions upon communiques and communiques. Yet nothing has been done. So, and the executive, they keep on reviewing salaries, they keep on this. The legislature, they are on their own. NJC should, because the Constitution vests in NJC the responsibility of paying remuneration and salaries pursuant to Section 84 of the Constitution. So they should have said, okay, these people have not been this. You have not reviewed the salaries and this.
Millard also touched on the budgetary allocation of judicial officers and made a call for investigative agencies to open the books of the judiciary and expose corruption in the mismanagement of the judiciary's budgetary resources. But are you saying that the judiciary does not have a problem of underfunding, but one of mismanagement of funds?
In fairness to Buhari, since he came to power, he has upgraded, he has increased the budgetary edition of the, and yet the problem still continues. And the judges are still complaining that most of them don't even know how much was budgeted. And because of our own discipline, otherwise, should one now go to freedom of information to insist on and demand suchness? But we are so disciplined that we keep quiet when this is. So what if we are talking about the basic infrastructure, the basic amenities that should make this? We are talking about electronic something. What are the facilities there? Have they bought in the facilities for everybody to be compliant? Have they bought laptops and computers for every judge? And that is part of either capital or recurrent budget. This thing, secure the Wi-Fi and all this thing. These are all the things that make the. Are they there? The management is ability to make optimal use of the little you have, while administration is you sustain the continuity. I think they are not managing their resources well.
The debate over the quality of people on the bench and the mode of appointment, that debate has been on for a long time now. Does Millard support a reform of the whole process?
I think so. It has to be reformed so that we go for the best and not just because of some mundane considerations.
What do we need to put in place to achieve that?
You have to check the integrity, you have to check the intellectual ability, you have to have the intellectual warehouse. Apart from the intellectual warehouse, he has to be very knowledgeable in law. Those are the things that make a judge. And even in the days of Moses, Those are the qualities that they make a judge. So a judge, the society cannot demand less. It has to be one of the best.
During your time on the bench, was there ever a conflict of interest? I mean, we know that politicians would always test their limits. Was there ever a time that there was a conflict of interest, and how did Milord handle it in the way that Milord did his job and somebody suggesting?
If for any reason there was a conflict, I have a duty to disclose. Either disclose to the two parties or recuse myself completely.
Situations like that did come up.
It's normal. It's normal. So when for instance you find that maybe what you have, there may be a conflict of interest, you have a duty to tell the other side, and then see they have had occasions to say, okay, I've been on this, I've been on this. What do you say?
With the demand for the resolution of international disputes in Africa growing strongly, the annual ICC African Conference on International Arbitration was held in Lagos from the 1st to the 3rd of June 2022. The conference, which was held in a hybrid format, provided plenty of useful and relevant updates on developments in the region, as well as an opportunity to examine the African experience in arbitration proceedings and the relationship between dispute resolution and inward foreign investment.
It's a gathering of elite minds in arbitration practice and top-class speakers to foster ideas on international best practice and upskill themselves in the field of dispute resolution by arbitration. With the growth of economies of nations and international trade, the relevance of international commercial arbitration to dispute resolution is not in doubt. The keynote speaker at this 6th ICC African Conference on International Arbitration is the Secretary General, Africa Continental Free Trade Agreements Area, AFTA. Speaking under the theme, African Arbitration, Consolidation and Transformation, the keynote speaker provided updates on the work of AFTA with regards to the implementation of an effective dispute resolution framework, including the activation and operationalization of dispute settlement body in Accra, Ghana.
We have now started, last year the operationalization of this protocol. We are now in the process of appointing appellate body members who will come from the length and breadth of our continent, who will be appointed within a short period of time. I'm hoping by the end of this year the process will be concluded. They will have tenure. They will not be subject to political whims. They certainly will not be subject to the wishes of the Secretary General, because they are protected in their positions. They are protected by the treaty so that they are able to provide impartial rulings that will advance the implementation of the AFCFTA.
The reality that we're about to enter into, which is the free trade area, it's our reality in this sub-region. And he mentioned the dispute resolution mechanisms that are in place already. And he mentioned something about technical competence as far as that panel is concerned. And lawyers form part of the dramatis personae in that dispute resolution space. And they also must be technically competent. And I think it's important for platforms of like this nature to be presented for us to gain that know-how to be able to effectively participate in that process.
Apart from developing competency, speakers also spoke about some of the other challenges that arbitrators encounter.
I'd like to mention what the Secretary General of AFCTFA said, that they're going to set up a body. In what way are those members of that body going to be appointed? Is there going to be a call for nominations on their website? Or are people just going to hear about it and then start applying? Let's start in Africa, beginning to appoint people on the basis of their qualifications and their experience, and making sure that we have a wide way of advertising.
When an award is published, in advanced countries most of the time, once they see the way the case is going, the loser knows he's likely to lose. And because he has signed an agreement that the award is final, and that the award is binding, they issue their checks. But that doesn't happen in Africa. So today people think that arbitration is just the first step to litigation. There's nothing we really can do about it.
And then some solutions for moving forward.
So countries that have been focused on promoting their cities as seats for arbitration have really been focused on strengthening the arbitration infrastructure, ensuring that the legal system and the courts are favorable to arbitration. So that really is essential, that the legal community, the business community comes together with that single purpose. Now, whether the arbitration takes place in Lagos or any city around the world, arbitration itself can still be and is indeed an important mechanism for Nigerian and African businesses.
The MBA is focusing at the moment on capacity building and development for its members. And we have what we call a social mobility type of philosophy, where we encourage the members of our association that are at the least of us to get up. And getting up means that we then invest in our people by encouraging and supporting them to attend this kind of trainings. And this particular training is actually very important because, of course, arbitration and international investment arbitration and all forms of arbitration has become very modern and very legitimate, especially with what was happening in our court systems. So that's why we're interested in this, and that's why we're part of it. So you have over 200 of our members who we've encouraged to be part of this activity today, and we're happy with the content and all.
And just before we go, a recap of some of the top trending legal stories in the news.
We begin with the report that the Federal High Court, sitting in Abuja, has granted the former governor of Imo State, Senator Rochas Okorocha, bail in the sum of 500 million naira and one surety in like sum. Justice Inyang Ekwo ruled that the surety must be a responsible citizen who has a landed property within the jurisdiction of the court. The judge also ordered the senator to deposit his international passport with the registry of the court and is not to travel outside the jurisdiction of the court without permission. The former governor of Imo State, Senator Rochas Okorocha, who represents Imo West constituency in the Senate, was earlier arraigned alongside Chinyere Anyim by the Economic and Financial Crimes Commission for allegedly laundering funds to the tune of 2.9 billion naira while serving as the governor of Imo State. The case has been adjourned to 7th of November 2022 for trial. Still in Abuja, the same Justice Inyang Ekwo has granted the request of the detained Deputy Commissioner of Police, Abba Kyari, to file more evidence against the federal government in a suit seeking to extradite him to United States of America for trial on criminal charges. Justice Ekwo granted the request following a motion on notice by his counsel, praying the court to allow Kyari bring additional documentary exhibits. Counsel to the federal government had, however, opposed the request on the ground that it was an attempt to cure deficiencies in the earlier documentary evidence adduced by the detained DCP Kyari. In a brief ruling, Justice Ekwo said that the court will have ample opportunity to determine the value to be attached to the additional evidence.
Let me give my order.
The suit is seeking to extradite Kyari at the request of the American government to face trial in his indictment in an alleged internet fraud by a Nigerian, Ramon Abbas, also known as Hush Puppy. In Lagos, the ban on commercial motorcycles, popularly known as Okada, has stalled the trial of Andrew Nice Omonikoro, the driver of a bus rapid transit BRT, who is alleged to have raped and murdered 22-year-old fashion designer Oluwabamiche Anyanwola. The Director of Public Prosecutions, Dr. Babajide Martins, told Justice Sherifat Shonaike that the Nigerian Correctional Service had taken the initiative not to let out any inmates following the rumors of riots by some commercial motorcyclists. He also said that the Lagos Island area has been known to be a hotbed during such incidents, and they intend to prevent any inmates from taking advantage of such incidents to escape custody. Following the development, Justice Shonaike adjourned the case to June 7 and 9 for continuation of trial.
To mention the names as I invite them to
And we round off in Adamawa State, where the Governor Umaru Fintiri has encouraged the judiciary to ensure that transparency, discipline and efficiency remain their watchword in carrying out their duties. The governor said this during the swearing-in ceremony of 4 judges of the state at the banquet hall of the Government House in Yola, the Adamawa State capital.
And that I will preserve, protect, and defend the Constitution of the Federal Republic of Nigeria.
According to the governor, his administration will not tamper with the sanctity of any arm, as he has granted unfettered autonomy to the judiciary and the legislature to make them function effectively for good governance. Governor Fintiri also reiterates that he remains conscious of the need to strengthen institutions through upholding the creed of fairness, equity, precedent and justice in all dealings with all arms of government as a general principle of good governance.
That's the program this week. Many thanks for watching. Don't forget that you can catch a repeat of this program or past episodes on our YouTube page. I'm Shola Shieli. Thank you for watching.